Good morning, everyone. Tiruna, will you let me know when I should go ahead?
You can start now. Thank you.
Hi, everyone. Tim here from the ICJ. Welcome back to the second day of our colloquium. And as you can see, we haven't skimped on the presenters for today. We have a very, very excellent lineup of presenters, so much so that we're going to have a split session to begin with, and then after lunch, we're going to come back with a joint session again to wrap up the colloquium. My job today is just to welcome you back on behalf of the Center for Human Rights and the ICJ. I'm the ICJ's lead on economic, social, and cultural rights, and I'm based here in Johannesburg, South Africa. I just wanted to do a very short recap of yesterday. Yesterday, we had different sessions, including keynotes and panels, both on economic, social, and cultural rights, and on sexual orientation and gender identity. And we've sort of framed it so that we're building up to the afternoon's panel, which I encourage everyone to join, where hopefully we'll combine the conversations that we've had and come back to a very full conversation and directly dealing with poverty and inequality and the nature of poverty and inequality as it affects, in particular, LGBT persons in Africa and around the world. Today, what we're going to do is we're going to first, after this introduction, have a video, an animation that we'll play today, which is different to the one yesterday. If you saw it, this one is on economic, social, and cultural rights in Africa. It very much for those of you who are not going to be able to attend the session on economic and social rights now, tries to sort of get to the crux of why it is the judicial enforcement of economic and social rights in Africa is important, and particularly in the context of COVID-19, why it's been important. And then we'll get to a discussion on that in the economic and social rights panel. After that, we're going to have a little bit of housekeeping, I believe, from Tiruna. I'm going to hand over to her for that. And then we'll split off into these two sessions where we'll have separate discussions and come back eventually to have a conversation later on, as I've said already. But from us, the purpose, I hope, is clear of this event, and hopefully it's clear that we will be moving forward and trying to advance both the center's work and ICJ's work, and hopefully supplement the work that's already going on amongst civil society organizations, lawyers, and judges all around the continent in developing jurisprudence on economic, social, and cultural rights and SOGIE. So thank you very much. Tiruna, can I hand over to you?
Throughout the African continent, the effects of COVID-19 have been deepened by wide-scale poverty and inequality. Staying home, social distancing, and regular hand washing is made more difficult by inadequate access to housing, water, sanitation, and other social services. Governments across Africa have implemented states of emergency and disaster, lockdowns, and business closures. Some of these measures have caused severe strains on livelihoods and employment, increased hunger and poverty. Economic, social, and cultural rights, ESCR, are protected by international and regional treaties, including the African Charter on Human and People's Rights. They include the rights to education, health, social security, work, housing, food, water, sanitation, and a decent and continuously improving standard of living. Courts have made important interventions to protect ESCR in Africa during COVID-19. In Lesotho, a court ordered government to provide access to personal protective equipment to health workers. In Malawi, a court declared lockdown restrictions unlawful because government did not simultaneously implement adequate social relief measures to compensate for losses of livelihoods. In South Africa, a court ordered government to continue providing food to school children, even during school closures. Courts have a crucial role to play if ESCR are to be made a reality in Africa. This role deepens during public health emergencies, where executive branches of government may take charge of far-reaching responsibilities. COVID-19 has highlighted failures by governments in Africa to take sufficient measures to realize ESCR before the pandemic. In Uganda, for example, underinvestment in the public health system and inadequate regulation of the private health sector hampered the ability to prevent, control, and treat COVID-19. This resulted in courts ordering the government to regulate the exorbitant prices being charged for access to oxygen supplies. Evidence-based policymaking is crucial in the responses to public health emergencies. In Madagascar and Tanzania, unscientific views about COVID-19 in government significantly hampered the rollout of COVID-19 vaccines, putting people at greater risk of sickness and death. From east to west and north to south, many constitutions in Africa provide legal guarantees for ESCR and allow for them to be protected by courts. African governments can and must continue to budget and plan for the full realization of all ESCR. Where governments fail to meet their international and domestic ESCR obligations, courts should continue to find innovative ways to give effect to these rights without fear, favor, or prejudice. Governments should accept that this is an appropriate role for courts to play. African countries must do this to prepare for future public health and climate emergencies and redouble their efforts to eradicate poverty and eliminate inequality.
Good morning, everyone, and thank you for joining us. My name is Taruna, and I will be starting the facilitation for the ESCR session. But before we break up into our groups, I just wanted to go through the general housekeeping rules. So we do have interpretation available for the session in the main room. So we do apologize for the lack of interpretation in the breakout room. Unfortunately, the Zoom software made it a bit difficult to arrange for that. But we'd like to request that if you could please name yourself on Zoom so that we know who's present and who's with us. And you're also welcome to add your pronouns. Along with that, this webinar will be recorded, and the ESCR session and the afternoon session are currently being live streamed. So that will also be available after the day has ended for viewing. We also kindly request that you keep your mic on mute unless you are directly addressing the floor. And towards the end of the sessions, there will be time for questions and comments. However, you are welcome to type out your questions and comments during presentations and addresses if you have something you would like to share. And then for the breakout room sessions, what we are going to do is open the breakout room, and you will have the option to join the SOGIE session. And if you encounter any difficulties with joining the room, please just type in the chat function that you would like to specifically join a session, and we will be able to automatically assign you. So the way it works is that you use your control panel to select the breakout room icon, and it will give you the option to join the SOGIE session. If that doesn't work and you need to be manually added, we will send a request to you, and you will have to just accept that request, and then you will be able to join the room. So I think that should be pretty straightforward, but we are available to assist if there are any challenges that you are experiencing. And I wish you all a fruitful morning and that each session goes well, but I think we are now ready to begin. So the SOGIE session is open. Please do join if you would like to join. I see that it's open. And then for the ESCR session, we shall continue after opening remarks are given by Michael Nyako. So I think we can give it a minute, Michael, before we begin, while people are joining the SOGIE session, and then we can start our session in the main room. So just to reconfirm for everyone, we are going to be hosting the ESCR session 1 in the main room, and the SOGIE session is going to run simultaneously in a breakout room. I see that there have been quite a few people who have joined the SOGIE session, so I do think we're ready to continue with our session now. Michael, if you're ready.
Yes, thank you, Karuna. Dr. Orragu is asking if you can allow him to share his slides. I think he has a presentation that he would like to share. So if you can allow him that opportunity. But otherwise, good morning, good afternoon, good day to everyone, and welcome to our discussions for today. Yesterday, we did lay the background discussion on the international human rights position and how regional and international human rights monitoring mechanisms can facilitate the enforcement of economic, social, and cultural rights. And today we want to domesticate that conversation, to localize it within the domestic context and look at how specifically national courts can navigate the intricacies of enforcing economic, social, and cultural rights. Certainly, this is not a new debate. This is a very old debate that has been going on since the adoption of the Universal Declaration of Human Rights in 1948, and the subsequent discussions that went on that led to the adoption of two separate treaties, the Covenant on Economic, Social, and Cultural Rights as a separate document from the Covenant on Civil and Political Rights, because of these agreements among state parties who were negotiating for a binding treaty on human rights at the time. So today we would begin with a keynote speech from Dr. Nicholas Orragu, who is a passionate and committed human rights advocate. His main areas of specialization are economic, social, and cultural rights. And he has worked extensively and researched in this area of interest, including assisting the Federation of Women Lawyers in Kenya in research, policy, and legislation drafting for the National Human Rights Commission of Kenya. He's consulted with the United Nations Human Rights Refugees, the Commissioner for Refugees, and a lot of other organizations, including the UN Population Fund. Currently, he's a senior law lecturer at the University of Nairobi, where he researches and teaches about comparative constitutional law, international human rights law, tax and human rights, and the international humanitarian law, gender equality, among others. He also has research interest in climate change, disaster, and the law. He researches also about sustainable development and has been a visiting research, a Marie Curie research fellow at the University College of Cork.
What's the line?
Apologies for that interruption. Please, if you're not speaking, may you please mute yourself so that we don't have interactions from you.
Is it possible to ask her to make me a host then, so that I can have the props presentation? Because none of us are.
Are we good to go, Tiruna?
I think
Tiruna,
let's try.
Can you confirm if we're good to go? Okay, thanks, Imperial, for confirming that we're good to go. So, I mean, without spending a lot more time on this, Dr. Orragu has also been involved in the drafting process of a recent general comment on sustainable development that was drafted by the Committee on Economic, Social, and Cultural Rights. And we're happy to have Dr. Orragu here to give us a keynote speech on recent developments on economic, social, and cultural rights, looking at what courts around the continent are currently doing in enforcing the rights to health, housing, social security, adequate standard of living. Dr. Orragu, thank you very much for gracing us with your presence today, and we're looking forward to your keynote speech.
Thank you so much, Michael, for that introduction. I'll go straight to the point, but a lot has already been done by the video that has been played. So if we look generally at some of the things that we can consider to look at in the context of economic and social rights, we see that we have the situation of economic and social rights in the continent is quite dire, especially in the context of the COVID-19 pandemic. We have been shown by the COVID-19 pandemic that we have inadequate healthcare systems in the context of healthcare infrastructure, health equipment, human capital, financing for health, as well as systems of procurement for health equipment. And we have also been shown that we have over-relied in most instances on partners to support our healthcare systems. And when partners have challenges that they have to address, then we don't have adequate financing to be able to address some of the health challenge and other social challenges that we face. We have also seen inadequate international solidarity in addressing common challenges. We have seen this in the context of access to vaccines, the cost of the vaccines, vaccine nationalism, and IP protection that has made it almost impossible for many Africans and African countries to actually have access to vaccines. Our countries have been forced to to put in place containment measures, be it lockdowns, be it curfews, be it social distancing, and other required measures to be able to contain the pandemic. And these have adversely impacted economic and social rights to the point where many African countries are experiencing recession or GDP contraction of about 2 to 5%. And this we have seen in the context of contraction of trade, reduction in tourism, inability of governments to have sufficient taxes, reduction in remittances, and the increase in the debt burden that African countries have had to struggle with. So this has made, this has led to the reduction in governmental resources for the provision of social goods and services to members of the public. The containment measures have also led to loss of income, and loss of livelihoods in terms of job losses, business losses, and as well as the reduction in social safety nets. We have also seen inaccessibility of public goods and services as a result of the COVID-19 containment measures, with education facilities being closed, and there being inequality in access to education vis-a-vis those who have access to technology and those who do not have access to technology. We have also seen challenges in relation to access to healthcare for those who have capacity and those who do not have socioeconomic capacity. In the context of the pandemic, we have seen challenges in relation to access to shelter, with persons who have lost their jobs not being able to continue paying rents, but also destruction of settlement by government institutions in the context of forced evictions. And generally, we have seen increase in poverty and inequality in the continent, with almost over 40 million people being driven to extreme poverty as a result of the pandemic. We have also seen several challenges that affect the possibility of effective implementation and fulfillment of economic and social rights. We've seen impunity and breakdown of rule of law, where there has not been sufficient balance between development and conservation on the one hand, vis-a-vis the protection of the rights to shelter, the rights to water, the rights to livelihood on the other hand, as well as system of protection of a breakdown of social protection mechanisms that have been put in place to enhance access to economic and social rights. We are also, in the context of the pandemic, still facing the challenge of climate change, as well as lack of our capacity to adapt effectively to climate change, which in essence has reduced the resilience in terms of livelihoods of very many communities in the continent. We have seen effects of climate change, like extreme weather events like floods, droughts, which have affected access to water, access to food, access to livelihood and livelihood security. We have seen also effects of climate change affecting ability of people to settle, leading to displacement, and therefore lack of access to education and health, and also generally increasing insecurity and conflict. What are some of the main challenges that the continent faces in the context of full enforcement of economic and social rights? The first thing that we have is a challenge of underdevelopment and high levels of poverty and inequality in the continent, which means that more and more resources are needed to be able to provide social goods and services to members of the public in order for them to be able to live lives of dignity and fulfill their economic and social rights. If you look at the level of need vis-a-vis the level of resources that are available, then we see that we still have a challenge of implementing substantively economic and social rights in the continent. We also have lack of effective constitutional, legal, and policy frameworks. Not very many countries have effective justiciable economic and social rights. It's almost countable countries with substantive entrenched constitutional rights that relates to economic and social rights, with South Africa, Kenya, and Zimbabwe being examples, and other countries like Nigeria, Uganda, and Malawi relying on indirect protection through an integrated process where civil and political rights are used to enhance the protection of economic and social rights. We also have limited utilization of international human rights instruments, norms in the domestic system. We still have the dichotomy of dualist and monist states, with most of the dualist states not effectively integrating and utilizing international law in their domestic jurisdiction, and this, in essence, limits the ability to be able to use the economic and social rights that are entrenched in international human rights instruments to enhance protection of economic and social rights at the domestic level. In those in countries that have ratified international legal instruments, we have seen a refusal to ratify or to make declarations giving direct access to members of the public or civil society actors to have direct access to these international and regional enforcement mechanisms. And we saw this during yesterday's discussion with direct access to the African Court on Human and People's Rights, with very many countries either not giving direct or not making declarations to give direct access, or actually withdrawing their declarations and making it impossible for people to have access. So we have, on the one hand, the inability of the domestic framework to utilize international human rights frameworks, and on the other hand, we have the refusal of countries to actually allow direct access to international and regional enforcement mechanisms. Then we have the challenge of enduring positive negative rights dichotomy, which we have had for quite some time because of the Cold War and the realities of the diversity in understanding of human rights between the East and the West, that looked at economic and social rights as being second generation rights, and civil and political rights as being first generation rights, and therefore civil and political rights being justiciable while economic and social rights not being justiciable. Of course, subsequent to 1993, we had an affirmation of the interdependence and interrelatedness of rights, subsequent to the International Human Rights Conference. But we still have challenges in many countries where this dichotomy of civil and political rights on the one hand and economic and social rights on the other hand have continued. We also have the challenge of the counter-majoritarian dilemma, where there's a thinking that courts do not have the capacity to undertake socioeconomic and policy budgetary decisions, because these decisions have polycentric repercussions, and therefore courts are not able to effectively balance. And this has come in many cases in the context of the political question doctrine, which was one of the issues in the case of Sehwad, the maternal health case in Uganda, where the issue was basically that the government had failed to make provisions for maternal health, leading to death of women in the context of delivery. And this was considered to be a violation of the right to life and the right to health. When this case was submitted in court, in the Constitutional Court, a preliminary objection was raised, indicating that provision of healthcare was had policy and budgetary implications, and therefore the courts were not possibly substantially enabled to make determinations around issues of policy and budgets, because those were properly legislative and executive roles. So the case at first was struck off on the basis of this political question doctrine, but there was an appeal to the Supreme Court of Uganda, which basically asserted that the questions that had been raised were judicial questions that could be answered by a judicial institution, and therefore the case was sent back to the Constitutional Court to be able to hear it on its merits, with an affirmation that the political question doctrine should not disable a court to have a substantive analysis and adjudication of economic and social rights challenges. So this case was heard on its merits, and actually the Constitutional Court therefore affirmed that failure of the government to put in place effective maternal health services was not only a violation of the right to health, but also led to maternal mortality and morbidity, and therefore was a violation of the right to life. And also the court affirmed that this violation was also a violation, was a cruel, inhumane, and degrading treatment to women who were then not able to get substantive assistance in the reproductive because of lack of reproductive services. Other challenges that we have seen in the context of implementation of economic and social rights and their adjudication in the continent is a conservative legal culture, both in the bar and in the bench, which has made it quite difficult to have progressive interpretation of critical economic and social rights principles. So basically we have had all courts and all judges being given responsibility to undertake interpretation of new rights, or almost the circumstances of new wines in old wineskins. And we have not been able to get very progressive judgments from these old judges with conservative legal cultures. And also, if you look at the Attorney General offices in many countries, they have not substantially been able to recognize the justiciability of economic and social rights, and also have had very conservative interpretation of the standard of progressive realization, which in essence, many of the arguments that have been made by the government is that economic and social rights are subject to progressive realization, and because of this, they should not be justiciable. But more and more, there has been substantive understanding by courts of what progressive realization is, which basically requires that there is progression and prohibition of retrogression. A state has to show that it's actually taking steps, and those steps that are reasonable to be able to actually achieve the full realization of economic and social rights. And also, of course, have been able to make a more substantive determination of what maximum available resources are, and also affirm that in the context of limited resources, there has to be prioritization of the needs and the needs of vulnerable groups through the implementation of low-cost targeted interventions. This was affirmed by the Committee on Economic and Social Rights in General Comment number 3, paragraph 12. and general comment number 15, paragraph 13, which says that if there are no sufficient resources, at least the state is required to put in place effective measures to address in a priority manner the needs of vulnerable groups. Courts have been able to affirm this, and in many instances where the needs of vulnerable and marginalized communities have not been met, and the government is arguing that there's no available resources, then the courts have affirmed that as a priority, the resources that the government has should be looked at in their entirety. And if there are any resources that are available, it should be directed towards meeting the economic and social needs of the most marginalized and vulnerable groups. Also, there has been an understanding that progressive realization takes into account the obligation of international cooperation and assistance, which in essence requires that states do not look just within for resources, but should also look outside to partners, to international partners for assistance if they're not able to get sufficient resources to meet economic and social rights. The other challenge to implementation of economic and social rights has been the limited associative capacity, as well as the necessary financial as well as human resources for a rights revolution for socioeconomic transformation. There are no sufficient non-governmental organizations or public-spirited people that are actually undertaking economic and social rights litigation seriously in order to achieve a rights transformation through litigation. So more and more civil society actors, more and more lawyers should take on public interest litigation and bring these cases before the courts and substantively argue them for the courts to be able to make informed decisions. And then the other challenge is the acceptance or the inacceptance and application of extraterritorial obligations. This is important, especially in the context of the work of businesses, especially transnational businesses, as well as in the context of climate change, where international businesses undertake activities that violate fundamental rights, or because of activities of states that leads to climate change. How do you then hold those transnational businesses and those states accountable? There's need to affirm and utilize extraterritorial obligations to hold these particular transnational organizations and states accountable. But courts have not been able to do so, which in essence has limited the capacity of courts to actually effectively protect economic and social rights. So we were supposed to also look at some of the recent developments in judicial enforcement of economic and social rights. The first recent development is the increased utilization of historical and of history and context in adjudication of economic and social rights. So more and more courts are looking at the history of their countries, the reality of poverty and inequality, and the context within which they have to make a determination, and then seeking to balance different rights in order for there to be social justice in the context of adjudication around economic and social rights. So we can look at an example of the case of PO versus Attorney General, which was determined in Kenya by the High Court of Kenya. And the essence of the case was that there was a challenge to an act of Parliament, the Anti-Counterfeit Act, which had broadly defined generic medication to also be included as counterfeit. And this would have affected access to generic ARVs, especially for persons living with HIV. And so this Anti-Counterfeit Act was challenged as a violation of the rights to life, the right to dignity, and the right to health. And in making a determination, the court had to look at the socioeconomic context of the case and the history of a lack of access to sufficient health provisions in the country. So the court looked at the high prevalence of HIV, as well as the many people that were infected and affected by HIV/AIDS. It also looked at the fact that HIV/AIDS was a threat to health, to life and to socioeconomic development generally. It looked at the fact that there were very many children, around 110,000 children that were born with HIV, and that this could have been prevented if there was a substantive access to medications to prevent mother-to-child transmission. It also looked at the fact that persons living with HIV were mostly poor and were reliant on generic medications, especially generic ARVs, in order for them to be able to sustain their lives. So in the context of this reality and context, the court then had to make a determination in balancing the right to IP protection for owners of medications vis-a-vis the critical rights to life, dignity, and health of those who needed this medication, especially persons living with HIV/AIDS. And in making a determination, the court said that that should the act be implemented as it is, the danger that it poses to the right of the petitioners to access essential medicine, which they require on a daily basis in order to sustain life, is far greater and more critical than the protection of the intellectual property that the act seeks to protect. So the right to life, dignity, and health of the petitioners must take precedence over the intellectual property rights of patent holders. So because the court was able to look at the context and the reality of the use of generic medication and the impact, the adverse impact that definition of generic medication as counterfeit was going to have on the lives and health of people living with HIV/AIDS, the court was able to make a determination in balancing the right to protection of intellectual property vis-a-vis the rights to life, dignity, and health of the people, and made a determination that was more protective of the rights to health, dignity, and life of the petitioners. The other thing, which is a recent development that you can look at, is the horizontal application of economic, social, and cultural rights. We have seen that at the international level, there are efforts to hold businesses or transnational corporations accountable for human rights violations. And this has also been a challenge in many jurisdictions in the continent. We saw the case of SERAC versus Nigeria, where it was not possible to hold Shell accountable because of the lack of provisions that enabled horizontal application of economic and social rights. So many of the new constitutions have entrenched the possibility of horizontal application of economic and social rights in the Bill of Rights. And a case that we can look at, which was also determined by the Supreme Court of Kenya, is William Musembi and others versus More Education. And this was basically in relation to forced eviction that was done by a private developer. And when this case was brought to the High Court identified that there was a violation. The forced eviction was a violation of the right to dignity, adequate housing, and the rights, the special rights of children and the elderly. And the High Court awarded damages. But when the case went to the Court of Appeal, which is the old wineskins, they were not able to substantively appreciate the new wine, which is the economic and social rights in the Constitution. And therefore, they set aside the High Court decision and the award of damages that had been issued by the High Court. So when this case went to the Supreme Court, of course, the Supreme Court affirmed that evictions of the petitioners was a violation of their rights to human dignity, right to security of the person, right to adequate housing, as well as the special rights of children and the elderly. And the court affirmed that private entities have an obligation under the Constitution not to violate rights, especially the rights that are contained in Article 43. And because there had been a violation by this private institution of these particular rights, they were held accountable and they were required to pay damages to the petitioners that had been affected, with the court ordering the private entity to pay $150,000 to each and every petitioner in that particular case. So affirming that even private entities when they violate fundamental rights, can actually be held accountable for that violation. And this was a holding in the context of evictions that had led to the violation of the right to adequate housing. Then we can look at utilization of development clauses. Courts have become substantively pro-majoritarian actors, looking at their context and being able to make a determination to enhance access to justice and to ensure social justice in the context of enforcement of economic and social rights. So courts have become, both for those courts that have development clauses in their constitutions and those courts that do not have development clauses, they have been more substantively progressive in making determinations around protection of economic and social rights. So we can look at an example, the Micro and Small Enterprise Association of Kenya versus Mombasa County government and others, where it was also a case of eviction of traders from where they had done businesses previously, and there was no provision of alternative places of doing business. So they brought a case before the court on the basis that that eviction from their trading place had violated their right to life. Even though the Kenyan constitution made provisions for economic and social rights in Article 43, these petitioners had not utilized Article 43 and instead had only utilized the right to life as the anchor for their petition. The court on its own motion, however, decided that this case was properly or should have properly been brought under Article 43, and it on its own motion then included Article 43 as part of the rights that had been violated in this particular context, with the court saying that this court, in the interest of justice, shall deem the petitioner's application as brought also under the provision of Article 43 of the Constitution. So even though we have a system of adjudication where each and every party should be able to bring up their cases, courts are becoming more progressive and looking more at enhancing access to justice and ensuring substantive justice, and not utilizing technicalities to deny people access to justice. Like in this context, the court affirmed that there was a right to livelihood and gave orders that required the Mombasa County government to provide alternative places of business to ensure that these petitioners were able to continue their livelihoods. Another case that you can look at in the context of progressive utilization of development clauses is the case of Mutual Welfare Society versus Kenya Airports Authority, which is a case that has been discussed quite substantively in the continent, relating to demolition of and eviction of people, and the court affirming that even where people are landless and they occupy public land, and they establish their houses there, they acquire a right to housing in that particular land, even though they do not acquire title to that particular land. So this, in essence, enhances protection from eviction and ensures that in the context of evictions, the guidelines on evictions have to be followed to ensure that people are actually adequately given notice, that they are sufficiently prepared, and that the substantive relocation plans that are developed to ensure that their right to housing is not affected in the context of that demolition and eviction, and that they're not rendered homeless as a result of governmental action to demolish and evict them from the land that they have been living for a period of time. Then the utilization of international law in domestic decisions. More and more, we are seeing courts in Africa utilizing international law in domestic decisions, both substantively as binding norms, but also as progressive, persuasive norms. And we can also look in that context at the case of Mutual Welfare Society versus Kenya Airports Authority, where the court had to actually make a determination as to the applicability of international law in making decisions on economic and social rights in the in the country. And the court held that looking at Article 2.5 and Article 2.6 of the Constitution, these provisions of the Constitution requires Kenyan courts to apply international law, both customary and treaty law, in resolving disputes before them, as long as the international law is relevant and not in conflict with the Constitution, local statutes, or final judicial pronouncements. The court also affirms the applicability of soft law principles, especially those contained in general comments of treaty bodies, as being persuasive in nature and that could be authoritatively used as interpretive aid for courts in undertaking adjudication around economic and social rights. There's also, courts have been more firm in protecting the economic and social rights of indigenous populations. Of course, we talked yesterday about the African Commission on Human and People's Rights and Others versus Kenya case, which was presented by the African Commission to the African Court in the context of the eviction of the Ogiek, an indigenous community, from the Mau forest, a forest that they have lived in for long and that they have used as a source of their livelihood. And the court affirmed that that eviction was a violation of the right to land, as well as other rights like the right to property, the right to wealth and natural resources, as well as the right to economic, social, and cultural development. So in effect, the courts are recognizing the new norms that have been created around indigenous people's protection and affirming that indigenous peoples are entitled to protection of their land rights, even if they do not have substantive documentation that indicates their collective entitlement to a piece of land that they have lived in for years. Something that has disturbed courts is the balance of rights, especially the right to strike vis-a-vis the essential service providers. And this is in the context where, for example, nurses or people who work in water service provision institutions or power service provision institutions, whether they can go on strike, and when they go on strike, the impact that has on the substantive economic and social rights of people, like the right to health, the right to water, the right to electricity, and things like that. And this was a question in a case that was determined by the African Court on Human and People's Rights, Sebastian Germain Marie Aku versus Republic of Benin, where the question was whether essential service providers and members of the security forces could actually go on strike. And this case was quite similar to the South African case that had been determined around the South African National Defense Union versus the Minister of Defense on the possibility of collective bargaining and industrial action by people in the disciplined forces. So question has been asked, how do you then balance the right to strike vis-a-vis the need that essential services should continue, even in the context of like, and whether the responsibility of the judicial officers to make a determination on, or it's a decision of the legislature to be able to make a balance to ensure that when members of essential service, members in essential service provider, people who work in essential services, if they go on strike, there should be a possibility that each and every person can still have access to these particular services. The African Court on Human and People's Rights were not quite able to substantively balance this right to strike vis-a-vis the need for essential services, and actually found that the right to strike is contained in Article 15 of the African Charter, and that once a state has recognized the right to strike, then it cannot refrain from allowing each and every cadre of employment to have access to that particular right, even if they provide essential services. So this is a question of balance of access to essential services like security, water, health, and justice vis-a-vis the collective labor rights of essential service providers. And I think it's an important thing, a point of discussion that we can have as to how that these two rights can be balanced to ensure that there is no violation of critical economic and social rights in the context of a strike. The other possibility that was raised in the case of Sebastian Germain Marie was the possibility of justification of retrogressive measures. Is it possible that states can put in place retrogressive measures without actually violating economic and social rights? So this was a question in the case of Equal Education and others, with the Minister of Education and others, a South African case that challenged the Ministry of Education and the MECs of 8 provinces of South Africa who had suspended the National School Nutrition Program during school closure as a result of the COVID-19 pandemic. And the issue was whether that closure was a violation of the right to nutrition of children, and whether it was a retrogressive measure, and whether it could be justified in the context of the COVID-19 pandemic. So the court held that the provision of basic nutrition was inextricably linked with the provision of basic education, and that the state had a positive obligation to fulfill the rights, as well as a negative obligation not to impair access to the right. So the first provision of this National School Nutrition Program on the basis of the first opening of schools was held to be an unjustifiable retrogression on the right to nutrition as well as the right to education. So the question was it justifiable retrogression? The court said it was not justifiable retrogression because if retrogression is to be justified, there has to be careful consideration based on legality and proportionality. And it's therefore critical that we understand that this possibility of retrogression in the context of economic and social rights, but that retrogression has to be legal and it has to be proportional. And the criteria for assessing whether an action is retrogressive or not retrogressive has been provided by the Committee on Economic and Social Rights in General Comment number 19. Paragraph 42, which says that in order for an action, retrogressive action to be justifiable, it has to be reasonable. There has to be comprehensive examination and consideration of alternatives. There has to be genuine participation of the affected groups. There has to be a consideration of the long-term impact of the action and whether it deprives the right of its minimal essential content. If it leaves the right to be illusory, then it has to also be subjected to independent national review in order for it to be a justifiable retrogression. Lastly, I know my time is up. Lastly, there has been a use of dialogic remedies in order to be able to substantively implement economic and social rights. And we have seen this with many more and more courts using structural interdicts to enhance the protection and promotion of economic and social rights in the continent. So thank you so much. I think I'll stop there.
Thank you so much. I think that we've really been asked some powerful questions around the balance of rights and what that would look like in practice. I am going to please ask for any questions that we may have as it relates to the wonderful keynote address that we've just been given. So please raise your hands if you have any questions, and we'll be more than happy to take them. In the interest of time, we will not be able to take all questions, but we would love to take a few of the questions that have arisen out of this wonderful presentation. So I cannot see any raised hands. Do we have any questions? Oh, there we have a question from Timothy.
Hi, I think, thank you very much, Dr. Orragu. In the 2 minutes that we have left over, I think that I'll ask you one question. And I think we might get into it in some of the conversations later on. But the real question for me moving forwards is, we can see progress in the development of a jurisprudence, and I think that that's quite clearly articulated. But what is the impact of this slow progress, I would say slow, on the actual ability to combat poverty and inequality? And is there a need to rethink an approach which might really be able to, let's say, touch sides in relation to really seriously combating poverty and inequality, or should we continue to invest in the same incremental development?
Thank you so much for that question. There's no silver bullet, I would say, that can be utilized to be able to enhance reduction of poverty and inequality. The reason why there's litigation in the first place is because of recalcitrance in the political institutions of the state, basically the executive and the legislature. And if there were effective implementation of laws and policies and effective financing of those policies and laws by the legislature, then I think we could go very far in reducing poverty and ensuring that economic and social rights actually make sense. Because the reality is that even with these very, very substantive decisions that are being made by the courts, there is still a challenge of implementation of those decisions because of impunity and a lack of adherence to the rule of law in many of the countries that these decisions are being made. So you find that cases are being determined, effective judgments are being issued by very progressive courts, but the executive does not implement the decisions. And even where the laws and policies that have been put in place, there's no effective implementation of those laws and policies. There's no effective resourcing of the institutions that have been empowered to implement and to provide public goods and services. And so the challenge, I do not have an answer as to how or what specifically can be done to ensure that we utilize economic and social rights to reduce poverty and inequality, but we have to undertake sustained advocacy. And where sustained advocacy is not working, we still have to rely and utilize the courts and have that associative capacity, social movements coming together and actually working together to ensure that these decisions are substantively implemented.
Thank you so much, Dr. Orragu, for answering that question. In the interest of time, I'm going to request that we will hopefully be able to answer some of the other questions in our next panel, but I will then ask that we begin with our panel discussion. Our panel is titled Judicial Remedies and the Effectiveness of Economic, Social and Cultural Rights Adjudication. What lessons have we learned so far? And I will now hand over to Michael Nyako to do the introductions of our panel as we begin what promises to be quite an exciting discussion around this topic. Michael, thank you.
Thank you very much, Alma, for the brief introductions. And thank you very much, Dr. Orragu, for that quite comprehensive keynote speech. We're happy to have you remain on the panel to answer some of the questions that we couldn't pose to you because of the time allocations. And we hope that you are able to join our panel in the next hour or so as we continue to engage in localizing and domesticating the conversation, more specifically learning about country case studies and examples from across the continent. This morning we have a very powerful lineup of judges and academics from across Africa who would share with us their views on the specific issue and the judicial remedies and how courts around the continent are navigating the issue of adjudicating and providing substantive relief for persons whose economic, social, and cultural rights are not either being respected, protected, or fulfilled by states across the continent. Our first speaker on the panel is Judge Zionita from Malawi. She's a High Court judge and a member of the Women Judges Association of Malawi. She actively involves herself in providing legal advice to women and children, holding legal clinics and offering mentorship programs in Malawi. She previously worked as the Malawi Energy Regulatory Authority Director of Legal Affairs and Board Secretary for that particular institution, and Board Secretary for the Ministry of Justice and Constitutional Affairs as a State Advocate and Legislative Council. She has also worked with several NGOs and trusts dealing with women, children, disability, and sports, just to mention a few. Judge Intaba, we hope that we can receive your discussions on how courts in Malawi are navigating the intricacies of providing judicial relief for violations or the lack of fulfillment of economic, social, and cultural rights. And after that, we will have another presentation by Judge Odunga. I would speak more about his own profile when it's time for him to speak. So Judge Intaba, if you're ready, well, we're ready to have your presentation.
Thank you. I'm sorry. I was hoping not to be first, but here we are. I guess from the point of view of the judiciary, I think in Malawi, one of the biggest things we rely on heavily is the fact that we are a constitutional democracy, so to speak. And as such, the Constitution sets the agenda in terms of how we interpret and how we look at the laws, that the cases that come before us, whether they are violations, whether interpretation of particular acts or policies. And I think we rely heavily on Section 11 of our Constitution, which talks about we must promote the values that are underlying an open democratic society. We take full account of Chapter 3 and Chapter 4, which is our bill. Chapter 4 is our Bill of Rights, and Chapter 3 talks about the national principles and policies and all those things. And it is there, I think, that's where we set a lot of our issues, that the cases that have come before the courts, whether they are within the civil political arena or the economic and social cultural rights arena. But it is interesting that in all of that, Section 12 I think underpins our very essence of our constitutional principles. And I think it is there that the inherent and dignity of each human being is capitalized, I think, when they come before the law. And that's, I think, the issues that a lot of our court systems in the country have tried to uphold, and where they can enforce the laws that are in the country. In terms of economic and social cultural rights, I think the biggest issue that comes into play, most times they relate a lot to the right to work, right to a safe, whether it's a safe environment, whether it's the right to health, in some aspects, the right to health. But it is interesting, the biggest aspect of the rights is the intersectionalities that we've seen throughout the system. And as far as back, I think as 2006 or 2007, I remember of a particular case, which was it was called Gebo Basangano versus the Attorney General and the Ministry of Home Affairs and Prison Services. It's on prisoner rights. And you see in that case, the concept of justiciability coming into play, where the court was arguing and looking at the fact that people were arguing about the respondents, meaning the Attorney General and others, were saying, oh, there's non-justiciability of the matters before the court. And the court was saying, no, it is clear that the arguments are reminiscent of the long-established principle that prison authorities possess complete discretion regarding the conditions of confinement of prisoners, and that the courts had no authority, not even jurisdiction, to intervene in this area. It is interesting, they said that principle belongs in the old days, and when the human rights culture was in rudimentary stages of development. But in present day and age, when we have a new constitutional order deeply entrenching human rights, and where human rights culture is fully fledged and continues to bind all public institutions, court cannot stand by and watch violation of human rights in prison as complained of by prisoners. Prisoners may have their right to liberty curtailed by reason of lawful incarceration. They have retained all other human rights as guaranteed by the Constitution, whose guardians are the courts. What happens in prisons is no longer sacrosanct. And it is interesting that in this particular case, the prisoners were asking for rights in terms of the cell space. They were asking rights in terms of clothing, food, health, and all those issues, they were terming them prisoner rights, but the courts were saying, no, these are not prisoner rights. These belong to you as human rights. And even though they're in the economic, social, cultural sphere, the fact that you're coming here because you're incarcerated and you're looking at the facts, at the civil political issues, we still are going to say, look, the regulations that deal with what you should be given as clothes, what you should be given as food, are not sufficient in this day and age, especially looking at the human rights issues that come into play. And Gabriel Masangan also makes a very interesting aspect in terms of the policy interventions that when, in terms of where people claim, where the, not people, I should say,
Has the judge been booted or booted herself?
I think the judge has boosted herself, so let's just give her a moment to rejoin. She's here again. Let me spotlight her.
I don't know what happened. It went off. What was interesting about in that case was that the court was saying that, look, even though you're saying as institutions you do not have the money because you're saying you have insufficient funds, that in itself does not mean you cannot obey the law. And you cannot give reasons that there's no funding as an issue. And it was an interesting provision of law that even went as far as to say, look, you are allocated funds, but why are you not using them for the right issues that they need to be done? That is to fulfill your obligations under the law. And that is to meet the minimum standards which you have placed on you as your duty bearer in terms of the right to food, the right to clothing, the right to a proper space in terms of self space. And although the decision was given by the court in 2007, to date, I can safely tell you that the things that the court ordered have yet to be implemented. And that's the problem we have with when it comes to economic and social cultural rights obligations, that even though courts rule, the challenge that we seem to face, and I think this is an African country's issue, is the fact that they remain unfulfilled despite the legal obligations and despite the court's ruling that the same should be done. Fast forward to 2015 and thereabouts, we sat on a case which was dealing basically with the rogue and vagabond situation, but the three of us sitting in that constitutional court, this was in the Sogwanda case, realized that there's a major intersectionality between civil political rights and economic and social cultural rights, especially when it comes to certain particular rights that are in the civil space, where you notice that with the rogue and vagabond, the people that were being, should I say, incarcerated under that particular provision were usually homeless, were either sex workers, or there were people who were actually didn't walk or were drunk and were coming from a drinking spree. And in itself, we realized that the intersectionality between those two rights needed to be addressed, and it's something that needs to be highlighted, especially for the fact that a violation is coming through by the mere fact that a person was homeless, or mere fact that a person was walking from his home at 4 a.m. so that he could go and sell plastic papers at 6 o'clock in the morning, and he was caught by the police when they were trying to do their sweeps throughout the night. And it is for that reason that in the Sogwanda that we stress that laws that inherently render themselves to open an arbitrary discrimination, especially in terms of application or enforcement, is usually bad law. And the constitutional fundamental principles that we have, as in this country, that talk about human dignity and non-discrimination, as including for people who are homeless and people who are poor, should not be taken away. And when we look at those particular aspects, we found ourselves that we took away the section 184C and said, look, as long as it's used discriminatory, then it should not be applicable in our country. But we also, in that particular case, highlighted certain things that needed to have been done in terms of law enforcement or the law changing itself. And I said, this was in 2015. to date, but those particular issues that we had highlighted as orders, directory orders to the executive arm of government, they still remain unenforced, and even the ones that were directed to the legislative arm of government, they still remain non-promulgated. So those are the kind of issues that we're looking at when we look at the concept of economic, social, cultural rights as they exist in our country. They are enforced in our institutions, they are enforced in the courts, but the problem comes into play in terms of the enforcement once the court decision has been done. I would like to highlight one particular aspect that we continuously see, and now it's hit such a high, should I say, level, such high levels in our country right now. But yet in 2001, the Industrial Relations Court, which is a court of a subordinate court to the High Court, has been dealing with it from in terms of safe working spaces, which is the issue of sexual harassment, which is providing safe working spaces. Since 2001, there have been decisions from the IRC talking about it, that look, there is need for more to happen in our country when it comes to sexual harassment, especially in the workspace. But it's only culminated right now when we've seen a High Court decision that came through as recently as early this year and late last year, early this year, whereby a High Court decision has now said, look, sexual harassment is a big problem in our country. And then the Malawi Human Rights Commission has also gone and done a number of investigations in parastatal institutions and found that that is a major concern. But it is something that courts have been for since 2001 saying that there is a problem. The issue is the non-enforcement and the inability for the economic and social cultural rights to be, should I say, transversed into realities, especially when courts have actually stated that these are issues that need to be enforced, these are rights that need to be protected, and these are rights that need to be promoted. So our biggest challenge as we relate to issues of SOGIE is the fact that you will find that in the media, there'll be cases of such people whose rights have been violated within the SOGIE space, but you do not see them coming into the court space. And those continued inequalities and vulnerabilities are what is driving the continued violations and discriminations of people in terms of sexual orientation or gender identity. We also realize that people don't want to come into the court space within those particular rights, especially if you look at, if they're going to say, look, I was sexually harassed because of my sexual orientation at work, the fact that litigation is costly to them in terms of their reputation, their time spent, their resources, but also they still want to keep that job. And that is something that we're noticing. SOGIE issues are rarely finding themselves in court spaces in our country, whether from a civil political rights point of view, but more so in the economic, social, and cultural rights. They don't seem to be finding themselves through. And our laws and our policies already do not address a lot of these issues. You might only find them sometimes in the right to health policies, but you do not find them being properly implemented as per se. And I think it is from that point of view that we find there's a major problem with regard to the progressive realization of economic and social cultural rights in our country. That since, despite the laws, despite the courts are saying these are rights are being violated, these are rights that must be promoted, these are rights that must be protected. But the challenge comes into play in terms of the enforcement, the implementation by all sorts of people, whether they are legal persons, whether they are government institutions, or even between individuals themselves. So for us, in terms of, I think, looking forward as a judiciary in Malawi, I would say what we would need to really do is continuously be aware of the intersectionalities of the rights themselves, especially between civil political rights and economic and social cultural rights. And where necessary, where you are dealing with a case where those two come into play, to ensure that both those first generation and second generation rights are highlighted to the extent that they ensure that we promote and protect and enforce the constitutional rights that are at play. I think we continuously need to make sure that the progressive decisions that the judiciary has developed since 2000, should I say since we passed our constitution, need to be made aware so that they increase the space and bring people in to know that the courts are present and available to ensure that rights, when they are violated, are protected and promoted. We also, I think we need to ensure that these precedents are made known, because it reaffirms a country's human rights stance, especially for people who are being discriminated because of their sexual orientation or their gender identity. We also need to, I think, as an institution, as the judiciary, because we know that despite we are people that promote and protect human rights, there are also instances that we ourselves actually do violate the rights of people of sexual orientation and gender identity through our words, through the system not being service oriented to them, but also not being, should I say, responsive. And as such, we also need to ensure that our internal accountability issues are in play to ensure that where there's non-responsiveness on our nature, we deal with it. And lastly, I think one of the biggest things that we need to understand as a judiciary is as long as SOGIE continues to be a concern for us as Malawi and every country, the bias and discriminatory practices and policies and legislations that are out there will find their way into the system. And as such, the courts need to ensure that they don't have those biases, and the court needs to be responsive. And that necessitates that we do ultimately, at the end of the day, ensure that when cases come before us, we ensure we do them rightly, but we enforce the human rights that are there, especially the economic and social cultural rights that come into play. Thank you. That is all I had. Over to you.
Thank you very much, Judge Ntaba, and I'm sure there would be a couple of questions that would follow from your presentation, and hopefully we can explore them in the discussions that will follow. Well, one question that I have thought about myself is, for instance, we know Malawi has not a comprehensive list of the economic, social, and cultural rights that are protected within the Constitution. We find the majority of them as directive principles. And perhaps when we come to the discussion later, one of the things that we would want to understand is how the courts are navigating around, being able to enforce those directive principles, especially through the implied rights theory, as we saw, for instance, in the recent decision concerning the COVID-19 lockdowns, and how the court came to the conclusion that the right to social protection is actually indirectly protected with the Constitution if you take into consideration a combination of other rights as well as the directive principles. So very, very thank you for that comprehensive snapshot of how the courts in Malawi are navigating these issues. Next on our list is Judge George Vincent Odunga, who is a presiding judge of the High Court of Kenya in Machakos. He holds a Bachelor of Law from the University of Nairobi, and he has been an award-winning judge for a couple of years for his efficiency and bold rulings. In a number of years, he's caught at the Mlimani courts, the Commercial and Civil and Judicial Review Division was awarded the best performing and most efficient and fast hearing and in the determination of cases. And in 2018, he was awarded the Jurist of the Year award by the International Commission of Jurists for decisions that he made concerning one of perhaps the famous Kenyans right now, Miguna, who was deported to Canada on quite interesting reasons. So Judge George Vincent Odunga, we really are happy to have you here today, and we're looking forward to hearing from you about the experience of judges in Kenya when it comes to navigating the intricacies of adjudicating economic, social, and cultural rights. We know Kenya perhaps has a more progressive, legal framework in the Constitution, specifically enumerating economic, social, and cultural rights. But even in very progressive legislative frameworks, judges still find difficulties in how to navigate, for instance, what are the appropriate remedies to give, even if you find a violation. So we're happy to have you here, and we're ready for your remarks. Over to you, Judge.
Thank you, Michael. Good afternoon. I hope I can be heard.
Yes, you can be heard. Yeah.
Thank you. I think I'll be quite brief. I'm just going to give an overview of what we have been doing in Kenya. As you say, and you rightly pointed out, the Kenyan constitution is very progressive in terms of the Bill of Rights. We have Article 43, which falls under Chapter 4. Chapter 4 is the Bill of Rights. And that particular article provides for the economic and social rights. Our constitution describes the Bill of Rights as the framework for social, economic, and cultural policies. And while Article 43 expressly provides for the socio-economic rights, I look at Article 19.3b, find that the rights set out, it provides that the rights set out in the Bill of Rights do not exclude other rights and fundamental freedoms which are not contained in the bill, but which are recognized or conferred by law, as long as they are not inconsistent with the Bill of Rights. In my view, this article clearly provides for the application of other rights which are not expressly provided for in our Bill of Rights. And therefore, there would be no excuse for somebody to say that since this particular right is not provided for in our Constitution, it doesn't apply to us. As long as it's not inconsistent with the Constitution, that particular right applies. And any person who feels aggrieved can come to court for the court to give relief in respect of that particular right. Now, Article 19.3a provides that the rights and the fundamental freedoms belong to each and every individual, and they are not granted by the state. And therefore, it's not a question of the state giving you a particular right. That right belongs to you as a person, and whether or not it's recognized by the state, that right exists. Article 23a provides that to the extent that the law does not give effect to a right or fundamental freedom, the courts are empowered to develop it. In other words, our courts are empowered to interrogate a particular law or policy in order to determine whether or not it gives effect to a right or fundamental freedom. In simple terms, where a particular right, whether a particular law does not give effect to a particular right, is upon the court to interrogate that particular law and find out whether that law or policy gives effect to that particular right. As I've said, it's not only the rights that are expressly provided for under the Constitution that are protected, but there are other rights which may not be included in Article 43 or any other article of the Constitution, which the court ought to uphold. And it is this particular article that comes into force where the court is upholding a particular right or fundamental freedom that does not expressly find its way in the Constitution. Socio-political rights, as we know them, they are positive rights which enjoin the state to take positive steps toward their realization. And as opposed to negative political rights, the assertion of these rights and upholding of the same invariably sets the executive and judiciary on a collision course. In Kenya, for example, the invocation of these particular articles and many other articles has led to the judiciary and some of the judges being labeled as activists. The judiciary has, however, taken a view that a purposive interpretation of the Constitution, which we are enjoined to apply by Article 259, leads to the conclusion that the Constitution itself is activist And being activist, its interpretation must also be activist. And so interpreted, it follows that the courts must exercise considerable influence in policy making, and in so doing, clashes with the political arms of the government invariably become unavoidable. As a result, you find that at times, tension builds up, suspicion and mistrust between the politicians and judges arise based on the allegation that the judiciary is usurping the function of the policymakers. As a result, sometimes once in a while, threats have been issued either explicitly or implicitly. And as a result of these negative attributes, there have been a tendency by the other arms of government to disobey or just ignore the court decisions. And in a country such as ours, where the judiciary relies wholesomely on the executive to execute its orders, where such disobedience become the order of the day, the products of socioeconomic litigation become merely academic. However, notwithstanding these setbacks, in the exercise of judicial mandate, the Kenya judiciary has made quite profound pronouncements regarding a host of issues regarding socio-economic rights, and these include the rights to housing, the right to health. A lot, however, still remains to be done, and the biggest hurdle is the attitude of the political class, which views the judiciary's pronouncements as an intrusion in the field that is reserved for the executive. As a result of this, we have seen attempts by the legislature to enact legislation meant to curtail the role of the judiciary in legislative process. Attempts have been made to bar the judiciary from interrogating the constitutionality of certain acts of parliament. So far, these attempts have not succeeded. As I've said, there's also been the threats not only to individual judges, but the judiciary as an institution, leading sometimes to what somebody may call financial sanctions as regards the budget of the judiciary. These actions do hamper the ability of the judiciary to carry out its mandate and ability to ensure access to justice, since without access to justice, the judiciary's ability to protect human rights as envisaged in the Bill of Rights, it cannot be attained. The other problem that we have is that most of the litigation that we have in the countries as of now are centered around political rights. There's, for example, not much or none at all as regards the right to adequate food of acceptable quality, which is a right under the Constitution. The right for clean and safe water in adequate quantities is another right which not much litigation has taken place in the country. We are still struggling with the right to emergency medical treatment. We have had cases where hospitals have detained patients even after they become well as a means of having their fee paid. My view is that these provisions still need to be fully tested in order for the full realization of the socio-economic rights. It's, for example, not unusual to hear that a part of the country has no food at all, while in the other part of the country, food is going to waste. And yet, nobody comes to court for the court to make a determination regarding these particular rights. The other handicap that we have, the realization of the rights, is lack of expertise in the relevant field. For effective litigation and realization of the product of litigation, a lot has to be undertaken in terms of preparation, and the undertaking of the actual litigation. As we are all aware, litigation can sometimes be a very expensive affair if it requires the input of experts. For example, if you are dealing with the right to adequate food of acceptable quality and clean and safe water in adequate quantities, it requires quite a bit of research, in-depth research in the field of nutrition and aquatic science before you can make a determination regarding what exactly is required. And that requires quite a bit of financial input. And lack of this means that proper litigation cannot be undertaken, hence limiting the realization of these rights. Again, the judiciary itself cannot escape the blame when it comes to enforcement of these socio-economic rights. We do have Article 23 of the Constitution that gives the power to judiciary to grant appropriate reliefs. But you find that some of the decisions, you come across some of the decisions which still place the parties in a straight jacket, but by unduly relying on the rules of pleadings that bar the court from granting reliefs not pleaded by the parties. In such cases, the courts have failed to realize that they have to fashion a remedy appropriate to the circumstances of the case so as to give a relief to the litigants. In this kind of litigations, more often the remedy is one in rem. And therefore, whatever relief the court gives, it ought to keep in mind that such a remedy may not be restricted to the parties before the court, but apply across board. It's important to note that our Constitution at Article 23(3)(b) provides that the Chief Justice shall make rules providing for the court proceedings referred to in this article, which shall satisfy the criteria that formalities relating to proceedings, including commencement of proceedings, are kept to minimum, and in particular that the court shall, if necessary, entertain proceedings on the basis of informal documentation. If that being the case, then there's really no reason at all why somebody should be barred from being granted a relief simply because the pleadings are not proper. In certain cases, the court's decision themselves have failed to take into account the existing exigencies by crafting judgments in a way that makes them easy to execute. We are aware that the executive arm hates to find itself boxed in a corner. Even in the cases where it feels that it ought to have taken an action, it doesn't want to be seen reacting to a decision made by another arm, particularly not the judiciary, which according to the executive comprises of members which have no direct mandate from the people. And therefore it's important in crafting a decision that the court ought as much as possible make a decision that appear attractive to the executive by making the executive seem to be part of the resolution. This does not mean that the court is bending over to the judiciary in arriving at a decision, but in executing a decision that has been made by the court ought to as much as possible, make the executive part of the execution process so that the executive feels that it has a stake in the execution of that decision and it's not being compelled to execute a decision that has been made by the judiciary. In this light, the court may, for example, in the process, seek to have an input from some state agencies. I have heard in one case which were dealing with the right to housing to involve the Kenya National Human Rights Commission to ensure that my decision was complied with. Otherwise, you end up with a decision which is basically a decision on paper. Nobody bothers to comply with it. And because we do not have the mechanisms for enforcement, nothing much can be done. Again, the other problem we have is that when it comes to structural or interdict, in the course of executing a judgment, the parties come and they tell you that the matter has now been resolved. An example which I can give is a decision which I made compelling the government to ensure that those who go to look for jobs in the Middle East are secure. Their security is taken care of. And I ordered the government to get in touch with the government of Saudi Arabia to ensure that the people there are not at risk. In the course of execution of that judgment, the parties came and told me that they are already satisfied. They were now satisfied with what the government had taken in place. But the problem is back again. Same problem, which we have been seeing on the news, that people are going to look for a job, and then there's some mistreatment and ill treatment. So these are the kind of problems that you find when your decision is somewhere, what I will say is compromise, so that it does not realize what was intended. In conclusion, I would say that the rights and fundamental freedoms must be considered together. The right of choice, for example, in the political field, cannot be realized unless there's a right to impart and access information. The right to life makes no sense at all unless socioeconomic rights are promoted, upheld, and protected. The rights of vulnerable members of society similarly are unrealizable unless they are economically empowered so that they can make their own informed decisions, not based on the demands of the stomach. Let me reiterate what I said at the beginning, that strides have been made in the field of socioeconomic rights, but we have barely scratched the surface. A lot more remain to be done, and to do so requires the concerted efforts of all stakeholders and players in the justice chain system. Thank you very much.
Thank you very much, Judge Odunga, for that comprehensive points on exactly how the Kenyan courts are navigating these particular issues. Hopefully we'll come to questions and answers, and we'll get to understand more the specificities of the Kenyan situation. But perhaps I should bring in Dr. Orragu here. We had Dr. Nonfundo, who was supposed to give a quick remarks on the choice between the kind of remedies that courts are able to give in the adjudication of economic, social, and cultural rights. Dr. Orragu, I know in your PhD you wrote about a sort of transformative approach to interpreting constitutions, with your reference specifically to the Kenyan Constitution, and you also talk about a dialogic approach of some sort. If you could perhaps give some remarks on how courts can approach judicial interpretation, especially when it comes to the difficulties surrounding economic, social, and cultural rights, and the kind of political pushback that comes from the executive and the legislature because of the idea that they might be overly interfering in functions that might be better performed by other organs of government.
Michael, this is quite an ambush.
I apologize for ambushing you. I've just lost one of my panelists, and I'm trying to continue the conversation by making the best use of the time available. I hope that Dr. Nonfundo will be able to rejoin us, but if you can also provide some comments on this.
Thank you so much. I think if you look at what I was discussing, it has actually been discussed prior by Prof. Liebenberg, Sandy Liebenberg, and Prof. Mbazira. And we were looking at basically the possibility of courts looking into remedies that can effectively be able to enhance the realization of economic and social rights. And as Justice Odunga has said, some of the straitjacket remedies that we had for civil political rights, or for the previous litigation that was aimed at civil and political rights, were actually not able to achieve the substantive transformation that economic and social rights were intended to achieve in order to address issues of poverty, inequality, and a general destitution of members of the society. So we had discussions around what Justice Odunga has said, enabling the political institutions of the state, mostly the executive and the legislature, being part of crafting some of the remedies that can then be used to substantively address not only the immediate needs of the petitioners or the applicants before the court, but to make a substantive legislative transformation to be able to meet the transformational aspirations of these new constitutions that we had. So we looked at decisions like suspended declaration of invalidity, which in essence ensured that the state did not take away, if you look at issues of retrogression, the state did not take away rights that had already been granted as a result of a legislation that has been found to have not made constitutional master, but that has provided some form of economic and social rights to certain members of the public. So in this context, in order not to deny people rights that they have already acquired, but to ensure that legislation is drafted in a way that enhances provision for each and every person that is entitled to provision in that particular context, then the courts would grant or would affirm that the legislation itself has not made constitutional master, but because of the importance of its provisions, it should be retained for a period of time to give the legislature the opportunity to be able to look at and make changes to that legislation so that that legislation is inclusive in its provision. So we have seen several cases, not only starting with Canada, but we have also seen South Africa, Colombia, and even Kenya taking up these delayed declarations of invalidity to give the legislative arm of the state the opportunity to rectify the situation. And it's only in those instances where even after sufficient time is given to the legislature to change what was considered to be unconstitutional, and it fails to do so, that's when the unconstitutionality will kick in. The other remedy that has been discussed is meaningful engagement, which is contained within the participation and inclusion provisions of several constitutions that we have seen, and where the court, having determined that there has been a violation of rights, then gives an opportunity for the state and the petitioners, as well as other critical actors in the society, to engage substantively to find solutions to the problem or to the challenge which resulted in litigation in the first place. So meaningful engagement orders have been made by constitutional courts also in South Africa, aspects of it in Kenya, even though it has not been without challenge in the Kenyan context, where courts have said that for those institutions that are not parties to the litigation itself should not be included. But as Justice Odunga has said, he has made orders and has required that the Kenya National Commission on Human Rights be included in the process of engagement, substantive engagement, to craft remedies that are agreeable to the state, but are also agreeable to the petitioners and other members of the society that are affected by that particular issue that has come before the court. The third remedy that we have looked at is the structural interdicts, of course, having and with the supervisory powers of the courts to continue supervising until the remedy is actually implemented in full. And as I was saying previously, this is a remedy that has been accepted in different contexts, starting with the United States, with Brown versus Board of Education, getting into Canada, several cases affirming structural interdicts, Colombia, and the Supreme Court of India. And this was then picked by of course, the Constitutional Court of South Africa that has substantively utilized structural interdicts. And courts like the Kenyan courts, especially the High Court, also picked up structural interdicts as a very important remedy, because you're looking at governmental recalcitrance and governmental reluctance to implement decisions. And when the courts then undertake supervisory jurisdiction, it ensures that in one way or another, the case is kept alive. And if nothing happens, then the court is then able to make follow-up decisions to address the situation of violation of fundamental rights. The case or the applicability of the structural interdict became an issue of concern and contention in one of the most important economic and social rights cases, the case of Meatbell, where the High Court issued the structural interdicts. The Court of Appeal said the structural interdicts are not known to the laws of Kenya, and that once a case has been determined, the court becomes functions official. And this issue went all the way to the Supreme Court, where the Supreme Court was able to affirm that if you look at Article 23 of the Constitution, what's the most critical is that justice has to be served, and the court has to be able to give a remedy that serves justice. And the Supreme Court was able to affirm the applicability of structural interdicts in the Kenyan context. So the essence of this dialogic remedies is basically to ensure that political institutions of the state are involved in the processes of developing remedial remedies or developing plans to ensure that remedies are realized for those who have had their rights violated. And as it was said by Justice Odunga, who is one of our elders when it comes to constitutional litigation and decision making, I think it's critical that when the political institutions of the state are involved in the process of decision making, then it's easier for them to actually implement those decisions. So I think I'll stop there.
Oh, thank you very much, Dr. Orragu, for those remarks. It's open for questions and comments from the participants as well. You can type out your questions, but you can also use the virtual hand raising session. One question that I was quite interested in, especially to the judges, is really how much international human rights law and the guidance provided by treaty bodies and international courts playing in the adjudication of economic, social, and cultural rights, which I would let you respond to shortly. But I see that Tim has his hands raised. Tim, you can unmute yourself and ask your question.
Okay, I see my internet is shaky, so I'm just going to speak. Am I audible?
Yes, you are audible, Tim.
Thanks, Michael. While we have two judges here, thank you very much for your presentations at the International Commission of Jurists. Of course, we work a lot with judges and try and understand judicial process and what might be able to move it on and develop it in the protection of rights. Where Dr. Orragu speaks about a dialogic process, there are many different ways, I think, of approaching such a process. And one of the ways that is prevalent in Pakistan, India, and Nepal, and countries like this, is the suo motu initiation of proceedings, observing the fact that there is a harm in the public interest and appointing an advocate to represent the public interest and calling the government to court. I think that in the context of COVID, this type of thing seems to be appealing, from an activist perspective. But what we get told by judges all the time in South Africa is that there's absolutely no way, even if their powers are flexible enough to do this type of thing, that they would do it, because it would be a total shock to the system. I wonder whether or not, and I'm not asking you to put your colors to the mast as a sitting judge in your own court, whether or not you could maybe speak around this idea of suo motu powers that are used in courts like India, Pakistan, and Nepal, and why you think in the context of economic and social rights they haven't caught on in Africa.
Thank you, team, for the question. Is your hand still raised, or is it a legacy hand at this point?
Judge Odunga, do you want to start, or should I start?
Go ahead, Judge.
I guess one of the things, we call them amicus here, where you call for amicus to come in onto cases. I think Malawi, we've seen that amicus has been called on a number of times, and I don't think I've seen judges who have issues with amicus. I only remember of one particular incident where amicus was denied, but it was not in the High Court, it was in the subordinate court, and it had to do with the harmful and cultural practices case. But that in the High Court, I've noticed that judges do call upon people to give amicus. I have done it. I've done it on a number of occasions, and I remember even at some point when the case, a SOGIE case, had come into play in the High Court. I remember Justice Mwangulu then, before he retired, ensuring that there was even an amicus call put out in the newspaper to say that people needed to respond to the issues that were going to come before it in that case. That case never went anywhere, but at least I've seen the High Court, the court in Malawi actually take that into account a lot more than I've seen. I've not seen it in the Supreme Court, but I've seen it in the High Court more often, and not in the subordinate courts either. So I don't know if that helps with your question.
Thank you very much, Judge Ntaba. Judge Odunga, do you have any remarks concerning the team's question?
Well, thank you very much. Concerning the issue of amicus, I must say that we haven't had much use of it in socio-economic field. We've had a lot of it in political matters. My view is that it's really, really very necessary that we make use of it as much as possible, because some of these litigants who come to court, they basically come with what their problem is. Say that my problem is simply that I've been detained in hospital, or I don't have food, I don't have water, I don't have proper sanitation. So it behoves the court to ensure that the decision that the court makes is a decision that is a just decision to all the people in that particular status of the litigant. Now, unless you are able to call for a legal assistance from the experts in that particular field, there's a possibility that the decision that you may eventually end up with may not actually meet the situation at hand. So it's an area that we need to explore, and I agree that you don't have to wait for somebody to make an application to be joined. It is a matter where the court can take notice of the fact that you require some expertise in that particular area, and therefore it becomes necessary for amicus to join in the proceedings.
Thank you very much, Judge Odunga. Just a quick follow-up question on the amicus. Just following up from Dr. Orragu's presentation on this idea within the Kenyan system, especially that when it comes to meaningful engagement and structural interdicts, that only the individuals or organizations that are parties to the suit could be potentially, could participate in the engagement that will lead to an agreement between perhaps the litigants and the government or responsible government entity that is alleged to have been the one responsible for violating their rights. Could amicus, briefs be perhaps one of the ways through which a court that is faced with quite a structural challenge allow more participation in the decision-making process itself? For instance, when it comes to meaningful engagement, could a court invite a broader audience of interested stakeholders, National Human Rights Commission, NGOs that have, or academics that have specific interest and knowledge on these issues, to participate as amicus so that they become part of the record of proceedings, and then it makes it easier for a court to say, well, these people can engage with the applicants and the state respondents towards fashioning out a remedy that is broad and comprehensive and allows the court to determine these issues on a much more comprehensive basis. Judge Odunga, the question was directed at you.
Oh, sorry. Thank you very much. As Dr. Orragu said, the High Court made a determination that that basically was towards the structural interdict. The Court of Appeal said no, that you cannot have a remedy that no party sought. And you can't have a situation where the court is handling proceedings indefinitely. Well, that's what structural interdict means sometimes. And therefore, the Court of Appeal said that the court was functus officio once it gave its judgment. But the Supreme Court said no, structural interdict is now part and parcel of our remedies under Article 23. And now the problem again that we've seen with respect to amicus is that before being joined as a party to the proceedings as amicus, the court usually interrogates whether you have an interest in that particular litigation. The decision that have come from our court is that amicus ought to be somebody who is independent, who has no interest in the outcome of litigation, so that the only role of the amicus is to assist the court to arrive at a just decision. And that means that if you are coming from a particular school of thought, and the objection is raised that that particular school of thought is in support of one particular party, then you might find it very difficult to be joined as an amicus. However, it's my view that amicus might help in arriving at a just decision, where, for example, the parties are not able, due to lack of proper knowledge or expertise, to bring out the issues that are at hand. When it comes to execution, it may be something else, because execution now requires the assistance of the executive arm in terms of making sure that everything is put in place that will eventually lead to the realization of that particular decision or judgment. And that's where you need to craft a judgment or an order that makes the executive feel at ease with the decision which you have made. And that's where the executive sometimes tends to avoid, to basically ignore the decisions made by court, where they do not have an input, even if that decision is right and they believe in it.
Yes, thank you very much, Judge Odunga, for those remarks. So I had a previous question which was addressed to both judges, specifically on how much role international law or international human rights law should play in the adjudication of economic, social, and cultural rights. we have come to understand that in most of our jurisdictions, even though our governments sign up to all these international human rights obligations, there's not normally a follow-up domestication of these instruments. And yet there are a lot of people who have been deprived of basic socioeconomic provisions whose lives could have been improved if governments had domesticated these rights so that they could claim specific violations of their rights, or that courts could utilize international human rights treaties and the provisions that come from the monitoring organization bodies as a way of these rights. How much can we expect courts in Africa to utilize international human rights law, at the minimum, as an interpretative tool when it comes to the adjudication of economic, social, and cultural rights?
Let me start. I think one of the biggest things that we've seen as in Malawi is the use of international human rights law in terms of most of the things that come before us in terms of promotion of human rights and all that. I personally have used it in cases where I've seen the need for such. I can mention of two. I can look at the EL case, which was an HIV breastfeeding case, where a mother was in prison with a child who was breastfeeding, and I think the other one was another case of, I think it was a woman who was arrested while she was pregnant and literally was almost about to give birth for a non-custodial case. And so using the treatment of offenders and breastfeeding, the international guidelines with regard to that, we adopted them into the piece of the two judgments that came before me, because literally we did not have anything on board in terms of policy, neither guidelines nor systems in our country that dealt with those particular two scenarios. Yet the system is incarcerating and mothers with children. Furthermore, it's also incarcerating pregnant women whose health cannot be looked after because there's no infirmary for such in our institutions, and as such, the need to incorporate that is critical. And it's also I think we're also lucky in our country because, as I said, Section 11 and Section 12 of our Constitution and Section 9, which binds us as judiciary, says we must use international law in the interpretation. And that is despite the fact that it's not been domesticated nor ratified, by the mere fact that it's used for interpretation of the rights that are within the Constitution. So I think we've been lucky because of that, and we've been lucky further because the Supreme Court, I think in 1997, called upon the judiciaries to interpret the Constitution broadly, to give give effect to the rights that are within it. And as such, I guess that's one of the reasons why international law has become more prevalent in a lot of decisions that are dealing with human rights violations and promotion in the country. But also, it has also helped broaden, as you were asking, how has Malawi then started using the implied aspect of litigation issues, whereby the law, the right is not there, but its effect is necessary to come into play when cases have come before it, like in the COVID case itself. So I think that's one of the things that we've been lucky with as a jurisdiction, that the Constitution allows us to do that. And the Supreme Court has also moved further by stating, look, the Constitution has to be interpreted broadly and purposefully, especially when we're looking at human rights issues. Thanks.
Thank you very much, Judge Ntaba, for your remarks. Judge Odunga, if you have any very quick remarks on the
thank you very much. Our Article 2.6 of the Constitution provides that any treaty or convention, no, let me start with 5. The general rules of international law shall form part of the law of Kenya. And any treaty or convention ratified by Kenya shall form part of the law of Kenya and under the Constitution. Of course, we have a debate going around on monism and dualism. I'm not sure whether we can of now say that debate is completely dealt with. We haven't. I'm not sure. My view is that we have not properly dealt with it. And we can say that it's now agreed whether we are monism or dualism. But if you look at the article which I cited earlier on, that Article 19, that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law. It means that any right that is recognized by law, and it doesn't say that is municipal law, it says by law. And since under Article 2.5, the general rules of international law apply to Kenya, any law that has been enacted to protect the social economic rights, as long as it's not inconsistent with the Constitution of Kenya, applies to Kenya. That's my view of when I interpret those two particular provisions.
Thank you very much.
If I add to Jajadunga's presentation in relation to Article 2.5 and Article 2.6 of the Constitution. This issue of the applicability of international human rights law, both treaty and soft law, came up actually in a case that was determined by the Supreme Court just this year, 2021. The case of Mutual Welfare Association versus the Kenya Airports Authority. The High Court had actually acknowledged and used international human rights law, and even for lack of guidelines on evictions, used the guidelines that are provided for in General Comment number 7 of the Committee on Economic and Social Rights. So when the case went to the Court of Appeal, of course, the Court of Appeal said that had a very, very conservative interpretation of the applicability of international law in the Kenyan context. So this issue was one of the issues that the Supreme Court had to determine. And the Supreme Court looked at Article 2.5 and Article 2.6 that Justice Odunga has said, and actually affirmed that the Constitution requires law, Kenyan courts to apply international law, both customary and treaty, in resolving disputes. But they threw up a spanner in the works and said that provided that that international law is not in conflict with the Constitution, local statutes, and final judicial pronouncements. So even though it was important that the court affirmed the applicability of international law, it raised an issue of the hierarchy of international law in the Kenyan domestic jurisdiction vis-a-vis other sources of law. But apart from that, it also raised the issue of the applicability of soft law, and affirmed that even though soft law are not binding law per se, but they can help the courts as authoritative interpretations to aid the court in interpreting rights so as to fill lacuna in domestic law. So one of the things that, and Justice Odunga has said that we have not quite substantively appreciated and finalized the discussion as to whether we are monist, dualist, quasi-monist or quasi-dualist, as the arguments have been made. But if you look at the hierarchy of laws on the basis of the decision of the Supreme Court, where would you say that international law lie? If you're looking at hierarchy of laws, just after the Constitution or just after the statutes, or where? Because there's this provision in international law that you cannot use your domestic legal instruments to defeat substantive normative international law norms that you have accepted through ratification or through acceptance through opinion juris for customary international law. So where would you place, if you're looking at hierarchy, where would you place international law? Sorry to ask the question.
Thank you, Dr. Orragu. I'm not exactly sure if the question was directed at me or to Judge Judge Odunga, but I think that it's an open question.
It was directed to.
Yeah, I would take it as an open question that one would have to think about quite carefully when, going forward in the Kenyan session. But I think we're almost out of time, so I will just allow the panelists to give 1 to 2 minutes quick concluding remarks on their presentations, and we'll probably go the reverse, and we'll start with Judge Odunga, followed by Judge Ntaba, and then Dr. Orragu will come to you.
Thank you very much, Michael. My closing remarks is just to urge all of us to ensure that the socioeconomic rights are embraced and promoted and fully realized. Without realization of socioeconomic rights, the other rights basically are superfluous. You can't really say that you've realized them when you have not realized the socioeconomic rights, because it's from the realization of socioeconomic rights that come the right to dignity. And that the right to dignity, in my view, is the mother of all the rights. So it's important, before you talk about anything else, to ensure that the socioeconomic rights are realized. Thank you.
Thank you very much, Judge Odunga, for re-emphasizing the interdependence and interrelatedness of rights, because usually there's dichotomy of civil and political rights and economic, social, and cultural rights, or so-called generations of rights, are quite unhelpful, because in the end, rights reinforce each other. And one right essentially contributes to the enhancement of the enjoyment of other rights. And we need to more and more re-emphasize that these rights are interconnected, interdependent, and we cannot ignore some rights whilst hoping that if we only enforce civil and political rights, then people will be happy and satisfied with their lives when they don't have the material existence that actually enables them to be free and to interact more equally in society. Judge Ntaba will take your quick remarks, closing remarks.
Thank you. I think I'll stick with the judiciary. I think as long as we do not, as judiciaries, ensure that the full impact of the judicial decisions that we make, especially those that enforce and promote and protect economic and social cultural rights, are not enforced by the people that we have put a duty on. Secondly, are not known to the people that need to know them, in terms of especially to enforce, to protect their rights, but also to just be able to simply make sure a duty bearer is accountable as part of the supply and demand aspect, which is very critical in economic and social cultural rights discussion. So for judiciaries, we need to do more in terms of ensuring we highlight the rights themselves, the decisions that we've made on those rights, so that the people who actually benefit from those rights being enforced and promoted and protected actually know that we are able to enforce them, protect them, and promote them when they have been a violation or when there has been a discrimination. I think if we do not, we continue to let the executive and the legislature have more say in what happens with those rights, yet we know that the violations have a major bearing on people's right to life, which is, for me, fundamental, especially with the fact that if you don't have food, you don't have clean water, you don't have good housing, you don't have shelter, it means it's a culminating effect on the right to life that we all have. So ultimately, at the end of the day, I think judiciaries need to be more judicially active and not be, I'm trying to use the right word now, or let me use a metaphor, put its head out like an ostrich in the sand and say, look, I did my part, if you need to know what decision it is, come to me. It is our duty to ensure that we promote and protect and enforce constitutional rights, because we took an oath to uphold the Constitution. So those are my final thoughts. Thank you.
Thank you very much, Judge Intaba. I admire your diplomacy, and I'm encouraged by your encouragement to fellow judicial officers to be perhaps more open-minded and more forceful when it comes to their own judicial obligations, and not defer too much to the other organs of government where they can appropriately intervene and make reasonable changes in the lived realities of people who are suffering deprivation of socioeconomic rights and amenities. But finally, Dr. Orragu, if you can give us your concluding remarks as we wrap up.
Thank you so much. Justice Odunga has said that there are many cases that have not been brought before the courts, and I agree. And I think one of the most important things that we have to do is to build the associative capacity, to build the capacity of lawyers and litigants to be able to bring substantively prepared test cases before the courts, not only to achieve a narrow sectoral interest, but to achieve to realize the potential that some of our constitutions have of transformation of the societies that we have. Judges will not be able to make decisions if we do not put before them substantively argued cases to enable them to make those informed decisions, substantive decisions that we want them to make. For judges, I think courage and persistence. Our judges should continue being courageous in accepting and adjudicating on economic and social rights, and they should continue being persistent despite the challenges and the threats that they face in order to receive these cases, to make informed decisions about them, and to actually grant remedies that ensure that justice is achieved, not only for the litigants before the court, but also for other similarly placed individuals. And so in making determinations, judges should not only look at the people before them, but also look at more substantive judgments that can also address the plights of people who are similarly situated. On the people who are not here, the executive and the legislature, I think it's critical for us to continue advocating for the rule of law, for the affirmation and for the observance of the rule of law, and for the reduction of impunity, so that the legislature and the executive are able to implement legislation and constitutional provisions in relation to economic and social rights, and where they have been cited by the courts for lack of implementation, they should be able to accept and actually implement those decisions of the courts, so that people can actually enjoy more substantive with their economic and social rights.
Thank you very much for that succinct but very comprehensive wrap up of our panel discussion. I would like to say a big thank you to my panelists this afternoon, Judge Intaba, Judge Odunga, Dr. Orragu. I appreciate your time and your commitment to engaging with us and allowing us to learn from your wealth of experience and sharing with us your views as well. And we hope that this is just the beginning of further conversation that will continue to engage even among us as civil society, as judges, as people who are academics and are interested in analyzing how we can better promote, protect, and fulfill economic, social, and cultural rights. I also want to say thank you for everyone who stayed with us throughout this panel discussion. And those who are not here, we also thank you for your participation in the beginning. And I hope that this conversation will continue on, and that in the end, we would work towards a more equal Africa where the rights of the most vulnerable are promoted and protected. And I will now hand over to Tim for some closing remarks. Tim.
Hi, sorry if my camera work is shaky, but I've moved from the computer to the phone because it seems to be that my connection is not good enough with the computer right now. Thank you very much to the judges on the panel, Judge Odunga and Judge Ntaba, as well as to Dr. Orragu for your presentations and Michael for the excellent moderation. I think that there's a few things to say to sum up the conversation. I mean, the first would be that I think that, as Judge Odunga puts out, courts in Africa in general, not just courts in Kenya, have probably not more than scratched the surface of what needs to be done if we're going to use legal systems to try and influence poverty and inequality in Africa. That's definitely true. We've discussed, and Dr. Orragu has raised a range of ways that courts might be able to craft creative remedies and engage society, meaningfully engage society, in order to maybe improve on that somewhat. But as Judge Ntaba has emphasized, it's necessary for judges to not engage in head in the sands judicial decision making and constitutionalism. There's a need for judges to try and be proactive in thinking up ways of moving forward. My own contribution to this would be that I think that there's no reason to believe that we have arrived at, in South Africa or in any other country, the perfect way to litigate economic and social rights to ensure the fulfillment of human rights and the alleviation of poverty and inequality. Quite clearly to everyone around the world, with the impending climate crisis and with increasing inequality and poverty, both before and during COVID, there is a need to think about how all state entities, including the judiciary, can help to improve the realization of economic and social rights. And really, there's a lot riding on this, because without being able to do this, especially in the African continent, we know that ultimately the legitimacy of our institutions, which are very important in protecting human rights and the rule of law, are at stake. What I would say is that observing, and I'm very glad, by the way, that we haven't revolved around the South African court. This was also by design, because many of these conversations sort of pretend that the only courts doing anything on economic and social rights in Africa is the South African courts. But what I think that we need to think about is how to move forward, to build on jurisprudence that has existed, to try and ensure creation of crafting of remedies that are effective, so that we can ultimately contribute to, at some point, at least significantly and meaningfully alleviating poverty and eliminating equality on the African continent, as is necessary all around the world. Thank you very much again for joining and participating. To all three of the panelists now, including Dr. Orragu, we will, at the ICJ at least, definitely be in touch and be wanting to interact with you further in the future to engage on how we might be able to support and how we might be able to work together. So thanks once again, and I think that I can hand over to the facilitators now to indicate what the way forward for the day will be from here on.
Thank you so much. This really has been such a wonderful and a rich discussion, and I think that we really have come out with lots of ideas and lots of questions that have been asked. Thank you so much. So we now will be taking a break. We'll be taking a break until 3:30, and at which point we will then commence again with the second part of our session. And we are really looking at having an intersectional discussion that will also look at transgressive sexuality in Africa. So do please join us again at 3:30, and we are looking forward to the second session.
Thank you. Goodbye.